Okay, so we're going to finish up our lecture on the federal court system, and we're going to talk about the process that the Supreme Court goes through in order to hear cases. Okay, so the process begins with what is known as the writ of certiorari. And this is an agreement of the court to review a case. And certiorari is a Latin term that means to make certain. And it is sometimes shortened to the term cert, to issue cert. And so that's probably how I will refer to it. And so, in order to issue cert, the justices come together, and 4 of the 9 justices agree to review a decision of a lower court. So remember, they are not retrying cases, they are simply reviewing other cases from lower courts. And so, in order to take up the case, they must, 4 of the 9, so it's not even a majority, but 4 of the 9 justices agree to review the decision based upon Rule 10 of the Rules of the Supreme Court. And Rule 10 of the Rules of the Supreme Court says that, quote, cert is not a matter of right, but is to be granted only when there is a special and compelling reason. This can include conflicting decisions between circuit courts and state courts of last resort, conflicting decisions by 2 or more state courts of last resort, cases that address civil rights or civil liberties, and cases in which the federal government is an appellant. So, it has to meet one of those requirements outlined in Rule number 10. And so it either has to be because there is conflicting decisions between lower circuit courts and or state courts of last resort, conflicting decisions by 2 or more state courts, so meaning 2 or more state Supreme Courts have decided on something and they have decided differently, and there's not really a whole lot of uniformity to the rules, the rulings, if it deals with civil rights or civil liberties, or if the federal government is an appellate. Now, only about 1% of the cases that are appealed to the Supreme Court each year are granted a writ of cert, and so that's around 80 cases a year, anywhere between 60 and 80 cases a year, so it's not going to be much at all. But if it is voted by 4 of the 9 justices for cert, then the preparation will begin. And in preparation, attorneys on both sides of the case will submit their briefs. And briefs are written documents that present their case, essentially. And these briefs are oftentimes several hundred pages long, and they explain their cases utilizing precedent from other court rulings. So they try to convince the court of their viewpoint based upon precedent from other cases. Sometimes an amicus curiae brief is going to be submitted, which is a, quote, friend of the court brief. And what this is it's a information from an individual who is not a party to the case, but they might be submitting some kind of expert testimony, or it might be an interest group trying to sway the court one way or another. But after preparation occurs, then oral arguments occur. And oral arguments occur when attorneys on both sides of the case appear before the Supreme Court to present their positions and to answer questions. And so every individual who delivers an oral argument only gets a half an hour. They get a half an hour to make their cases and to field any questions from the judges. So they don't really get a very long time. And during this time, justices will typically ask questions about the case to the individual presenting the information. And so you have a 30-minute window to do all of that. Once oral arguments are held, then the justices will conference. And the justices conference on Wednesdays and Fridays. And the court has their conferences in strictly private meetings with no outsiders permitted. So it is just going to be the Supreme Court justices, all 9 of them, or whoever's sitting, in the conferences together. And they will not allow outside influences. What this does is it gives the justices the opportunity to speak freely regarding the case in secrecy, and allows them to have this back and forth debate as to whether which way to decide on the case. And so they discuss the case and they eventually reach a decision on the basis of a majority vote. Once they do this, then the opinion writing is going to occur. After the decision is reached, one member of the majority will be assigned to write the majority opinion. And this is the official ruling, the official opinion of the Supreme Court. And so the majority opinion, if the Chief Justice is part of the majority, he will assign the writer of the opinion. If he is in the dissent, then the most senior member of the majority will make the assignment. So they write what the court's decision is, they write how it was determined, and what precedent it is based upon. Because remember, they base things on precedent, on other rulings that have been created prior to the case that they are dealing with. Now, sometimes members of the majority will agree with the opinion, but they differ in the language of the opinion. They differ as to why. They have a different rationale of why they agree with it. And so they will author what is known as a concurring opinion. So I concur with this opinion, but I have a different reasoning as to why I voted in the manner that I voted. And then we also have the dissenting opinion. And the dissenting opinion, justices who disagree with the majority decision may choose to publicize their disagreements in the dissent. And so this will allow for the reasonings of the case and why they voted the way that they voted. And so there can be multiple different opinions written about a particular case. So there will be a majority. There could be concurrent. There could be dissenting opinions. And once these are written, then they are made public to the individuals of the United States, and we will see how the Supreme Court ruled. Now, this is a long process. It could take a couple of years for this to actually all come to fruition. So it's a very long and arduous process. So some of the key players involved in the process obviously are the justices. Interestingly enough, there is no constitutional qualification for a justice of the Supreme Court or a federal justice. You do not have to be a law school graduate. You do not have to be a former judge. You just have to be trained in the law somehow. And so it's fascinating that, in the other two co-equal branches of government, in the legislature and in the executive branch, there are specific qualifications that those running for office must meet in order to run for office, but not in the judiciary. I told you earlier in last lecture that we would talk about the Solicitor General, because that is the role Robert Bork played under Richard Nixon as number 3 in the Justice Department. So they are the third ranking official in the Justice Department. They're the top government lawyer in all cases before the Supreme Court in which the government is a party. And so they are essentially in charge of half of the Supreme Court cases that come before that court, and they are under the charge of the Solicitor General, and that Solicitor General is going to be the individual that argues in front of the Supreme Court in favor of the American government. And so they work very closely with the Supreme Court because it's going to be an individual that they see all the time. And then law clerks. Every federal judge employs a law clerk, and they do this so that they have individuals to assist in researching legal issues, to help prepare opinions. And so there are lots of law clerks, but getting to be a law clerk for a Supreme Court justice is a very plum top job. And every Supreme Court justice is assigned 4. They get 4 of law clerks. And this is a very high honor, and it's typically awarded to graduates of top law schools who graduated in their top of their class. And clerkships, as I said, are very prestigious and indicate that the individual who receives the clerkship is likely to rise to the top of the legal profession. And many of the Supreme Court judges that are currently serving actually were former clerks for the Supreme Court, and so they play a major role. It's like the staff that legislators have, but Supreme Court justices and other federal justices will have law clerks. Now, judicial philosophy. We need to talk about judicial philosophy. There's judicial philosophy called judicial restraint and judicial activism. Judicial restraint are sometimes referred to as strict constructionists. And if a judge is said to be a judicial, an individual who employs judicial restraint or is a strict constructionist, that means they refuse to go beyond the clear words of the Constitution in interpreting documents' meanings. In interpreting the document's meaning. They do not do much inferencing. They do not do much stretching of the Constitution. They apply the Constitution as it is written. Judicial activism, they believe, if you're an activist judge, they believe that the court should go beyond the words of the Constitution or statute to consider the broader societal implications of its decisions. And so they expand the interpretation of the Constitution when they feel it is socially desirable. And so they will go beyond what is physically written in the Constitution and interpret it in ways to sort of back up what they believe, if they believe it to be socially desirable. There are a lot of arguments that say the Supreme Court is very anti-democratic because they are appointed and they serve for life, and there's no accountability to the people. But there are studies in political science that actually suggest that if you look at the society of the United States at a certain time period and you compare it with the decisions that are made by the Supreme Court, they actually sort of coincide. They actually overlap. And the Supreme Court is not necessarily going to rule in a certain way that is not socially desirable for the nation. And so it depends on which justice it is as to whether or not they operate under activism or under strict constructionism. But you have to understand that it's not a conservative versus liberal thing. Sometimes we confuse conservatism and liberalism with restraint and activism because we hear such things on the media like liberal activist judges. And so a lot of the time, liberalism is associated with activism and conservatism is associated with restraint. But that is not the case, because you can have very activist conservative judges, right? And if we look at William Rehnquist, he was a very conservative judge, and his court was a very conservative court, but it was active in interpreting the Constitution in new ways, and interpreting the Constitution in ways that it felt like were socially desirable to society at that time. And so there is going to be a significant argument regarding judicial restraint and judicial activism, and which is the best policy to employ as a jurist on the Supreme Court or any federal court. All right, just a couple of quick things here. I wanted to show you some firsts. The first African American on the Supreme Court was nominated by Lyndon Baines Johnson, and he was put on that court. His name was Thurgood Marshall. The first woman on the Supreme Court nominated by President Reagan was Sandra Day O'Connor, and the first Hispanic on the Supreme Court was nominated by President Obama, and her name is Sonia Sotomayor, and she obviously still is on that Supreme Court. There are it's a very high honor to be able to appoint a certain or to appoint justices to the Supreme Court. Presidents really like being able to do that because justices are on there for life, and they can really affect policy far beyond the time when the president is in office, because the president can only serve up to 2 terms. And so after he leaves office, then these judges are still in place, and they can really affect the policies of that president for a very long time and employ those. So it is a very very high honor, and presidents really like to appoint justices to the Supreme Court. Only 3 presidents in American history have not appointed a Supreme Court justice. The first one was William Henry Harrison, who was, I think, the 9th president, and he only served 1 month before he died. And so his tenure in office was about 30-something days, not very long. So he didn't really have time to appoint a Supreme Court justice. The second one was Andrew Johnson. He was the 17th president that took over after Lincoln was assassinated, and he did not have the ability or the opportunity to appoint a Supreme Court justice. And then Jimmy Carter was the 39th president. He only served 1 term, and it just didn't happen that he got to appoint a Supreme Court justice. And so every president since George H.W. Bush has appointed 2. So, they can affect presidential policy for a number of years after that president leaves office. All right, so we're going to leave there, and this wraps up our lecture on the federal court system, and so I will see you in the next lecture.